Good afternoon, everyone. I'm David Kilpatrick, one of the board members for the ACC DFW, and I'm happy to welcome you to this CLE session, Managing Digital Data Privacy Risk. We're so grateful for our sponsor today, Norton Rose Fulbright, for all their continued support during this, difficult time that we've had for the past year. So with that, I'd like to introduce today's speakers. First, we have Tristan Coughlin. Tristan is a senior associate residing in the Dallas office, focuses her attention on international practice of cybersecurity, data protection, and privacy matters. She helps clients navigate the various state, federal, and international laws that govern protection of data. Additionally, she advises clients on data breach preparation, cybersecurity risk, including but not limited to conducting information security, privacy program assessments, and developing tabletop exercises. Online, virtually, we will have Daniel Rosenwig, is a lawyer with Norton Rose Fulbright in their Data Privacy Protection and Cybersecurity Practice Group in New York. He advises clients on compliance with data protection and privacy laws, including the gambit of CCPA, CAN-SPAN, GDPR, HIPAA, TCPA, as well as providing counsel on applicable data breach notification laws. Daniel also focuses on matters related to autonomous and connected vehicles and has experience with advertising, marketing, and regulatory investigations. And with that, I will turn it over to Tristan.
Thank you for being here today. I'm Tristan Coughlin, and thank you for the introduction just now. And this is my colleague, Dan Rosenzweig, who is joining me virtually. Today, we're going to be presenting on managing digital privacy risk. There we go. So our agenda for today, we're going to start with legal industry obligations regarding data protection. In the last 5 years or so, I would say the regulatory environment has really changed. And we're going to kind of walk you through what some of those nuances in the law now require and the penalties that can be associated if you fail to comply with these new regulations. We're then going to talk about what are the technical hurdles. There are a ton of nuances in these laws that require a sophisticated understanding of where your data is going, how you collect it, how you process it, who are you disclosing it to? And understanding that can often require a significant amount of technical understanding. So we're gonna go into where we see our clients have the most blind spots and how we help mitigate that. The last item we're going to address is the NT Analyzer solution. This is a client-side perspective. It basically stands in the shoes of a user, and it's an in-house solution we've come up with to help our clients mitigate some of this privacy risk.
Hey, so thanks, Tristan. Again, thanks for having me, everyone. Apologies I couldn't be there in person. I'm up in New York, and maybe next year I'll be able to fly down there. That's the hope. So to get started, ultimately, there are a theme of 4 obligations across the data privacy and security landscape. The first one is companies are obligated to know which third parties receive consumer data, particularly from their consumer-facing interfaces. So this is from mobile-facing apps, mobile-facing websites, et cetera, and several laws, whether it be GLBA, which regulates financial institutions, CCPA, and/or GDPR. The next is companies are required to accurately disclose those data practices. So, they must be in a position that they can accurately and transparently provide all of the information in their consumer-facing privacy policies and other representations that they make with respect to their data. Next, companies must be in a position where they can process and respond to data subject access requests. And these are simply just when a consumer reaches out to the company and says, hey, I'd love for you to provide a full report of all of the data you have on me. And this is true under CCPA, GDPR, and some other laws. It also relates to deletion. A consumer can also reach out to a company and ask that all of the data that is retained on them be removed and deleted. Lastly, so the first 3, 1, 2, and 3 are with respect to data privacy. the last bit, understand legal obligations and risks associated with the data security incident. This is the cybersecurity side of the shop. And this, of course, is something we want to avoid. This is in the event that a company were to incur some sort of incident that can result in them having to meet certain obligations with respect to notification. They need to notify a regulator, or they need to notify consumers with respect to their data practices and the incident that has occurred. So starting with the Federal Trade Commission, in the United States, we don't have yet a blanket federal law that covers data privacy and security. It's more on a 50-state basis and industry-wide basis. However, the Federal Trade Commission has become the de facto federal regulator through its Section 5 unfair and deceptive acts and practices capabilities. So at a high level, what we're seeing here is that a lot of companies are getting in trouble with respect to failure to inform their customers accurately of the data that they're collecting and or sharing with third parties. Also, they have not adequately protected that information so that it can result in some sort of breach or incident. And as Tristan alluded to a few minutes ago, the regulatory landscape as well as the industry landscape is very much evolving, and it's really focusing on a lot of nuance with respect to a company's data practices. So this is the federal side of kind of the shop, and the FTC is able to, at least until a federal law has been mandated, to kind of run through its Section 5 capabilities. So similarly, this is the state side of the shop. So state regulators similarly have the ability to bring about actions with respect to data practices for unfair and deceptive acts as well. So this is just a high level overview of those cases and those well-known enforcement actions that have been brought by the states against companies for, again, failure to disclose certain privacy and security data collection practices, as well as adequately protecting the data from inadvertent data leakage and or incident disclosure. So to add more fuel to the fire, and this is where it gets fun and a little interesting, for those that don't know, Apple has recently implemented its own requirements with respect to mobile-facing apps. And what you see on the left side of the screen is the data labels, and on the right side of the screen are the consent mechanisms. And I'll take a step back and kind of describe what these are. So the left side, the data labels, essentially what is required now by Apple is that anytime a developer or a company decides that they are going to either introduce a new app into the App Store, or they're going to make an update to an existing app, they are required to answer a very detailed questionnaire about their data practices. And the answers to those questionnaires will result in this data label that you see on the screen to the left. And the questions are very granular, and it goes through a lot of detail with respect to the data that is being collected and or shared from the mobile app. So from this can be something as traditional as name and number. It can also include device identifiers. So everyone, for those that don't know, a cell phone has its own unique identifier associated with it, as do routers and other hardware IDs. And all of that is for purposes of the CCPA, Gdpr, and now Apple has now qualified as personal information. So companies are in a position where they need to answer these questions accurately so that they can then provide their consumers on the App Store with accurate disclosures. On the right side is with respect to consent. So Apple has required a consent mechanism be implemented within an app if the app is tracking a user, and essentially that is a defined term of art by Apple, and that essentially means sharing data or using it for advertising purposes and sharing it with a third party. And it's very broad, of course, that's a very broad analysis. The next part of it as well is whether or not a device ID is being accessed by the app. And again, as you can see, and we'll introduce and discuss this a lot further, a lot more, a little bit in the future on this in this presentation. This is all very, very nuanced and very technical, and it's important that companies get it right. And what's very interesting is on the Apple side of the shop is with respect to these disclosures and respect to these requirements, they've actually said that personal information and personal data as defined by relevant law is considered with respect to these disclosures. So essentially that means Apple has brought in personal data, which is the term defined by GDPR, and also personal information, which is the term as defined by the CCPA, which again, just really highlights the fact that Apple has essentially really become its own de facto regulator with respect to how apps are presented on their app store. So the potential peril and legal conflicts that can result from these Apple obligations are pretty significant, and we believe should definitely be getting a good amount of attention. The first being that this can inadvertently create a conflict with a privacy policy. So taking a step back again for a second, if we look into this, Apple is requiring developers to go into App Store Connect, which is the development hub for all mobile-facing apps on the App Store, and answer these, again, very granular, detailed questions about data practices. Those same data practices are required by law to be disclosed in a privacy policy. And of course, and this is just how it works typically, on the privacy policy side of the shop, it's typically the legal team that's responsible for that. For the Apple and the dev side of the shop, it's the development team. So there's now an inherent disconnect and with respect to responsibility. So there may be disclosures or representations made in one piece, the privacy policy, and it's not made in the disclosures for Apple or vice versa. So it's very easy to make these kind of misrepresentations. The next thing is this is just more information that would need to be included for a data subject access request. Again, companies are required in these circumstances to provide all of the data that they collect on a consumer. So this is just another data point that they're collecting with a company is collecting with respect to its data. The next point, which we've already somewhat hit on, is that the data categorizations, again, are very gnarly. This includes search browsing history, it includes unique identifiers, it includes crash reporting, and it gets very, very nuanced on the kind of information that's asked with respect to the disclosures. And the last piece is that if this is not done correctly, if an update to an existing app or a new app does not have its adequate disclosures or does not meet the consent requirements required by them, then apps are already getting rejected from the App Store. We believe that Apple at this point seems to indicate that they have the ability to go in and see how an app works and whether or not the disclosures and consent mechanisms are accurate. And we're already seeing many major publications and media companies already reporting on this kind of activity, especially with respect to the privacy policy and the disclosures on Apple. It gives an opportunity for media companies and publishers and others to kind of highlight that there's a distinction and a conflict between the privacy policy and the disclosures, again, which again can just result in the app either being rejected from the App Store which can have real implications for a business, especially a big consumer-facing business that relies heavily on their mobile-facing apps.
And so we wanted to take a step back here. We're kind of talking about data protection and what you need to know, how you respond to data subject requests. You have to make the right representations as to what data you're collecting, how you're using it, how you're disclosing it. But at the same time, the other part of this is that these laws also contain data breach notification obligations. So we kind of wanted to go over those with you as well. A lot of companies, which we'll discuss further on in the presentation, don't realize what data they may be sharing with other companies. There might be inadvertent leaks from your website or your apps. In addition, a malicious actor may intentionally intercept data coming from end user devices that you entered into your app or a website that you intended to go to the company, but which is maliciously intercepted. So data breach notification laws in the United States, there are federal industry laws. For example, GLBA, that governs the financial sector. FERC and NERC govern the utilities and energy sector. HIPAA governs the healthcare sector. And then the FTC has general authority over the private sector. But every single US state has a different data breach notification law. It's a patchwork approach in the US, and whether or not a law is triggered depends on a variety of factors. So for example, access versus acquisition. Most state laws require that an unauthorized actor acquire certain data in order for data breach notification laws to be triggered. About 8 states require unauthorized access. So that means, for example, if an individual accidentally accessed certain data, which we'll get into data elements in a second, data breach notification laws could arguably be triggered, and you need to notify individuals and potential regulators. Data elements. All 50 states determined that personal data includes name plus social security number, name and driver's license number, and name plus financial account information, debit card information, or credit card information with a PIN or a password. However, most states have a variety of different data elements which also qualify as personal data. For example, username and password, biometric information, tax information, any sort of government ID under certain state laws. And even, for example, a session token. If you use a session token to authenticate into certain apps, et cetera, if those session tokens are acquired or accessed by an unauthorized actor, in certain states, data breach notification laws can be triggered. Also, 2 states now require notification upon unauthorized acquisition of date of birth. So the general data elements that are considered personal information under US law have been continuously expanding over the years. Most states also have a risk of harm analysis, although some do not, like Texas. A risk of harm analysis is essentially, even if there was the unauthorized acquisition or access to data, so for example, you inadvertently sent or leaked a spreadsheet that had a bunch of personal data in it, you didn't mean to disclose that data to like your third-party vendor, they email you and they say, hey, we got this, we didn't open it, we deleted it, here's a certification saying, we've gotten rid of it. Then in most states, you may be able to avoid any sort of notification to individuals or regulators because there is no risk of harm to the individuals. You have to keep a record of that risk of harm. But essentially, it allows you to kind of, as long as and risk of harm generally means identity theft in these consumer type protection laws. Certain states, though, such as New York, have recently implemented a risk of harm, which includes emotional harm as well. So it really depends on the state at issue. Notice to individuals and regulators. Certain states require notification within 30 days. So that means within 30 days of discovering the data security incident, under certain state laws, you're required to disclose to individuals and regulators within 30 days. Others, it's without unreasonable delay. We always try to hit 30 days because the most strict standards, and there really is no data security incident today, which only affects individuals in a single state. Typically, individuals throughout the United States and often globally are impacted. Regulatory notification requirements. So you may be required to notify regulators, and that's where a little more scrutiny comes in. So in certain states such as New York, Maryland, Massachusetts, New Jersey, Indiana, Nebraska, and a few others, you have to notify a regulator if a single individual in their state is impacted by a data security incident. So that means you have to submit a letter or a website portal. They all differ, of course, because every law is different. Every way you submit to the regulator is also different. Then you have to submit regulator notifications. In other states, such as Texas, if 250 individuals are impacted by a data security incident, or 250 Texas residents, then you have to notify the Texas AG. So it really depends on the thresholds by state and who's impacted. State regulators and federal regulators, again, this regulatory landscape concerning data protection and data breach notification has really shifted in the last 5 years. I would say 4 or 5 years ago, unless your data security incident impacted hundreds of thousands of people or garnered significant media attention, you weren't going to hear from a regulator. Maybe you'd hear from 1 or 2. And that's just because it was a very significant data security incident. A lot of people from their state were impacted. Today, we recently submitted regulator notifications for an incident. I got a response from an AG, and there was a single individual impacted in that state. And they sent 10 questions. They wanted to know all about this company's data security practices, asked for copies of certain policies, et cetera. And this was a single impacted individual. That never happened years ago. So in almost virtually every case now, depending on the regulator, we're gonna hear back from someone. And so companies need to be prepared to respond to those inquiries. In addition to the US regulatory environment, there's also the international regulatory environment. It's almost impossible to have a data security incident now that only impacts individuals in the United States. We are often dealing with global data security incidents, which involve leaks of data and or malicious acquisition of data from global companies who have employees, customers, et cetera, all over the world. As you probably all have heard of GDPR, the European General Data Protection Regulation, it came into effect in May 2018. It was really a novel kind of privacy law, an all-encompassing privacy law, and it also included data breach notification provisions, as well as penalties for failure to comply with either the data protection provisions and or the notification provisions. GDPR allows for up to 4% of global revenue to be fined if you're not in compliance with their law. These have recently become a reality. Marriott was recently fined approximately 99 million pounds by the UK's Information Security Office, Information Commissioner's Office, the ICO. That fine has been reduced to about 18 million pounds due to the mitigating actions Marriott took afterwards and the fact of COVID and the impact that's had on the company. But generally, GDPR fines are on the rise. Research suggests that between January 2020 and January 2021, GDPR fines went up 40%. European regulators, since GDPR came into effect, have issued about 200 million in fines. So it is something to take into consideration. Generally, these fines are being imposed for lack of security controls. The CCPA, the GDPR, they all require you to understand what data you're processing, how you're disclosing it, what you're doing with it, and your failure to understand those and have appropriate security controls around that data results in fines. We've had regulators essentially tell us that not having MFA on your email platform is considered negligence in the EU. So these are all things to be considering during putting your protections in place and compliance with the laws. During investigations, obviously transparency with regulators is key, not only in Europe, but across the globe. Regulators appreciate your cooperation and it's gonna get you a lot farther. We used to not want to provide as much information to regulators under the privilege argument, that sort of thing. We found, obviously, we still try to safeguard privilege, but we try to give regulators as much information as we can to help them feel comfortable with the mitigating actions that we've taken in the event of a data security incident. Appropriate and technical organization measures to be in place, I kind of just already touched on that, is really key, and that's what they're looking at, and that's what's going to get you a fine if they do investigate. Analysis of supply chain risk. We're going to talk about, I've kind of already mentioned, the inadvertent or the intentional threat actor that inserts them into your website or your mobile app and steals that data. That's a supply chain risk because that's an often case, it's a third party who's hosting your mobile website or your app or your website, and malicious code is inserted into that. And if you don't have appropriate controls, whether contractual or otherwise, if you handle your website or app yourself, that's a significant issue. I'm sure you also all heard of Solarwinds, kind of outside the scope of this presentation. Nation state actors were able to compromise basically a network infrastructure company who provided software, and it sent that out to hundreds of companies throughout the United States, and they were able to infiltrate certain companies, more of an espionage purpose. But again, supply chain, regulators are looking at that. Do you have appropriate oversight? And then cyber due diligence on acquisitions. So going back to that Marriott example, essentially the Marriott incident was a result of their acquisition of Starwood. And the ICO found that they hadn't done appropriate due diligence on the data protection and cybersecurity controls that Starwood had in place before they acquired the company. So it all comes into play, and it's kind of a wholesome picture that you had to think about when thinking about your compliance with these laws. Okay, this is more of an informational slide, but people like to see it, and I thought it's kind of helpful. The average cost of a data breach in the United States in 2019 was $8.64 million. Essentially, it is the highest in the world. Being the United States, there are a lot of different regulatory aspects that you have to address, but even globally, 3.86 million for the average data breach. This isn't your big data breach or your small data breach, just a very average one. So this can take a significant toll on companies. And it's not only this cost of the data security incident. In a large security incident, you will have external counsel and a ton of other third parties sitting with your InfoSec team for months, essentially going through what happened, responding to regulators. And so all that time when your teams could be doing something else, instead, they're dealing with the lawyers, dealing with the regulators. And so it can really be a big drag. And just to emphasize, breaches of 1 million to 10 million records, you're going to be at 50 million in potential costs. More than 50 million records, average cost is almost $400 million. So just kind of wanted to highlight that and this is not including fines that can be issued by regulators. This is just the simple cost of dealing with a security incident.
So now we're going to dive into why the technical hurdles. And as Tristan alluded to, right, a lot of these laws and regulations, and again, it's only evolving with respect to, you can think of Virginia that just passed its own law, CCPA has been amended to the CPRA, and just to name a few, and over 20 states have introduced their own privacy and security laws this year alone. So the technical piece is important, and I just want to take a second to say, we acknowledge that this is very nuanced and very technical. So we totally would appreciate and love any questions you may have. You can either ping us after over email or here at the end of the presentation. Please feel free, because again, the problems are inherently technical and it does get nuanced. So it's important to kind of get a grasp of that. So diving right in, so the four main problems are: one, companies are typically blind to the data leakage that we're discussing here due to traditional cybersecurity solutions really focusing on the web server, right? The client's and the company's own castle, if you will, right? They have their own fortress where they protect their own data, and it's very important that those security solutions be implemented and be maintained. But what happens actually, and Tristan will dive into this in a little bit with an illustration, is that the vast majority of the data that is subject to this kind of data leakage is actually coming from a website and or a mobile-facing app. And if you think about how we interact and access those websites and apps, that's done through our phones, through our computers, through our tablets. That, if you think about, is outside the view of the data center and the company's web server, right? It's my phone, right? The app is on my phone. So the data is coming from my phone. When I decide to go order my favorite pizza, I type in my name and address and I type in my credit card credentials into the app. So all of that data is being shared from my cell phone. So a lot of that leakage, again, companies are otherwise blind to it and don't have a full view of it. The next piece, and this is totally acceptable and actually really helps with aggressive development cycles and meeting deadlines and et cetera, is the necessary reliance on external code. And to take a step back and give a very high level illustration, it's not exactly accurate, but for purposes of illustration, this is kind of, hopefully will kind of provide an overview. Think about if your company decides they want to develop an app, or again, I love pizza. So let's say it's your favorite, you're deciding to develop a pizza app. And as part of that, you offer a delivery service feature. So to do that, you need to rely on GPS, and you also need to have some embedded map on your device, right? Embedded into your app. Now, a company typically in this high level illustration would have two options. They can either develop their own map and their location features directly in-house, which again can be very, very costly and time consuming, or, which is typically the route taken and totally acceptable, is we rely on a third party. That we all know the big names that develop apps, location services, and we decide to embed that SDK or third-party code into the app to assist with that feature, because they've perfected it, so let's use theirs instead of ours. But which again makes perfect sense, but as a result of that, ultimately, when that app, every time that app is being used, it quote unquote phones home to that third-party code that is now embedded in the app. And often those third parties that you've now embedded into your app have embedded their own third parties into their app, right? Because there are certain features in their own app or their features that they need assistance with. And it goes on and on. So that's kind of the important plug here, that there's a necessary reliance on external code other than your own. The next piece is number 3, an unreliable and unverifiable statement from vendors. And again, to no fault of anyone's own, they're not acting maliciously, they're just doing what they can with the information they have at hand. Typically, we will have a call with a vendor or with a client on the phone and talk to their vendor about how that app is envisioned to work or how it currently works on the ground. And instead, because that company, again, the vendor typically also relies on its own third-party code and also is blind to the data leakage, you're forced to rely on statements and questions as opposed to facts. And again, those statements very well may be facts, but we don't know what we don't know. So if they're unaware of certain instances, then they're of course going to be unable to accurately disclose that. And the last piece is, and this is really becoming more and more relevant as these laws become more broad with respect to their definition of personal information and personal data, which is that there is a lack of true communication often between the marketing, development, and legal teams. And again, not maliciously, no one's going out of their way to keep someone in the dark. It's more just with respect to the nuance surrounding the laws. What we find often with clients is that the marketing and development team aren't always typically aware that personal information includes a unique identifier associated with the phone, right? Or even an app install identifier or a hardware identifier. So when they're asked, hey, are we collecting personal information? They totally are correct in thinking that they don't, right? They come out and say with full intent, no, we are not doing that. We have our personal information on lock and we're good. So as a result, they will launch particular cookies on their websites or introduce new code into their apps to meet point 2, the necessary reliance on external code, which again will just lead into further risk with respect to those 3 or 4 requirements that we discussed up front, which again were 1, meeting your DSAR obligations, having adequate disclosures in your privacy policy with respect to the data you're collecting and sharing, and the categories of third parties in which you're sharing that data with. So these 4 problems really only really make it difficult to accurately meet those obligations. And this again isn't a hypothetical. We see this happening all the time. And with laws like the CPRA and Virginia's law and other laws on the books, and with Apple with their own requirements, these problems are only becoming more and more relevant.
So we kind of wanted to visualize what we're kind of talking about here. So wanted to start with, how this data leakage is occurring and when companies don't realize it's occurring. So, sorry. So the 3 rectangular boxes, those are your web server. That's your data centers. Those are then protected by, they're essentially your castle. Web server, data centers, they're your castle. The green box around your castle is the walls that protect the castle. And that's your typical cybersecurity controls, your endpoint detection response, your endpoint, your EPP, your bot managers, whatever else you have in place to protect your environment and the data within that environment. So then data gets sent from your environment to the end user's device. So your tablet, when you've decided to join a fitness app and you're entering, health information, maybe you have some biometric information you enter because it helps with some sort of part of the app. You're entering all of this information. Generally, that data should be going directly back to the company web server. However, oftentimes we've found that instead of going directly back into the environment where you have all these security controls, instead, the data is getting routed to third parties while it's also going back to your company web server. Unfortunately, companies have zero visibility of where the data is going from the end user's device before it gets back to their company web server with their traditional cybersecurity tools. So in fact, data could be, for example, going to ad networks, analytic companies, marketing, your social media platforms, or security solutions. Some of this may be intentional. For example, many companies do have data sent back to their marketing departments. It's disclosed in their privacy policies. And as long as that's disclosed, that's okay. But the inadvertent release of data is basically in violation of GDPR, CCPA, and other laws. So not understanding where your data is going puts you at risk because you are responsible for all of the data that your company is collecting via its website or its app. So it's extremely important to understand that. So a majority of companies don't understand that data might be being leaked. Not only may data be going inadvertently to third parties, but it also may be being intercepted. And so this kind of goes back to the MageCart example I alluded to before. Essentially, the MageCart is a consortium of malicious actors who basically insert a malicious script either directly into code on a website or an app, or they use malicious script to redirect users to a website, which then copies data that's entered into the website. Either way, essentially, the malicious script is acting as a skimmer. It's often used on payment card sites. Several local US governments or several local governments in the United States have been attacked by this. There's many of them, a large airline, Ticketmaster, but essentially, when this happens, you might not have any visibility into where that data is going and who takes it until you get a notification from the card brand saying, hey, we've noticed fraudulent use of over 60,000 of your cards, what's going on? And at that point, you have a serious data security incident. Similarly, even if the leak is inadvertent, if you discover this leak, you may still have disclosure obligations depending on the data that's being siphoned off to these third parties. And so when you don't know about it, you can't comply. So it's just key to understand that. And going back to the MageCart part, I think, so Ticketmaster, for example, they had malicious code inserted into their website and over 9 million European individuals were impacted. The ICO in the UK issued a fine of about 1.65 million, which doesn't seem too high, but it was because they found that they had a lack of security controls around their website and mobile app protecting that data. Another large airline also suffered this type of attack. They were issued a fine of almost 200 million. That fine has since been reduced due to COVID and other factors. But again, these are serious considerations that companies want to take into consideration, is that you need to understand what data you have and where you're sending it.
We've actually developed a tool in-house to help companies navigate this complex legal and technical environment. So the tool is called NT Analyzer, Network Traffic Analyzer. And essentially what network traffic really is just the communication between a device, so our cell phones, our tablets, our computers, and a web server, and through a request and response relay with one another. And it's just, a way that they communicate with one another to exchange information. So what the tool does is actually it identifies client-side privacy and security events. And when we say client-side here, we mean client in a technical sense, client as the cell phone, the tablet, the computer, not client like a company or our own attorney clients. The next piece is that the tool actually maps those technical events to legal compliance baselines. So what that essentially means is we're able to provide a full picture of all of the data that's being collected and shared from a mobile-facing website or app, and then it paints a full picture of all of the data as defined by that particular law, or in Apple's context, by Apple. So for example, let's say you're covered by the CCPA, the California Consumer Privacy Act, which again is a very, very broad law and defines personal information very broadly. What the tool will help companies do is navigate all of the data that's being shared, and then it will allow and collected, and will not only tell the company all of the data through the lens of how CCPA defines personal information. So it will actually identify those categories like unique device identifier or cookie ID or other technical nuance, as well as traditional identifiers like name and number. But it will also actually provide recommendations and mitigations. So something that Tristan alluded to before is that often, a lot of the time, the data is actually shared with legitimate parties, right? So the data is not shared often with, or hopefully not, with a nefarious actor, but instead inadvertently shared with a legitimate third party like Google or someone who would not be acting in the context of a hacker in the traditional sense. What is important, though, under these laws is that adequate disclosures, as we alluded to, be put in place. And if the company decides that they want to keep that third party invested into their code or into their website, that an agreement just be put in place, right? So knowledge is power. Here the tool is able to tell the company, the client, our client, hey, look, it looks like your app is sharing data with Google. Is that intentional? And if the answer is yes, then okay, recommendation, make sure you enter into a service provider agreement with this company to avoid violating or running afoul of laws like CCPA.
So this is just we wanted to present a visualization of the NT Analyzer solution. So essentially, the NT Analyzer acts as an intermediary of the data going from the end user's device back to your company's web server in that period when it's not protected by the castle walls. Essentially, it stands in the shoes of the consumer. So we've been able to analyze the network traffic, as Dan just referenced, for a variety of companies and have oftentimes determined that data is going to third parties that it wasn't meant to go to. And then we have to think about, what legal obligations that impacts on the company. We've also had instances where we've found malicious redirection. And again, we then have to analyze the legal obligations associated with that misdirection. Essentially, if you don't know what data you're disclosing, then you can't comply with provisions of the CCPA, the GDPR, et cetera. As Dan just mentioned, having that power is knowledge. Basically, going back to the castle analogy, you need to basically have an overview of not only your castle and your castle walls, but you need to have an overview of all data in your kingdom and where it's going, how it's going there. And so the NT Analyzer helps with some of those objectives outside of the typical cybersecurity solutions.
So ultimately, what the tool does is empower organizations and companies to really meet those legal obligations. And it identifies, as we said, the client-side risk that's being associated with the company's mobile-facing app or website. And one useful feature that's really worth emphasizing here, and this is just true with respect to compliance on the legal side of the shop, which is it's one thing to require a company legally to disclose all of the third parties that it interacts with, or implement features whereby they can tell their consumers or adequately process a data subject access request, right? The law says, hey, company, you are required to go ahead and process the consumer's data and then be able to provide all of that data to the consumer upon the consumer's request. So that's one thing legally, but technically, that's not always the easiest thing, right? So a technical nuance and technical compliance is required to comply with these legal obligations. So one useful feature of the tool is now, let's say we rewind for a second, we've identified a third party, right? And we've said, hey, we would like that third party to be removed. Their code was ingested into the app inadvertently as a result of the issues we alluded to earlier. We'd like them to be, taken out. Now, the legal team typically would have to go to the development team and say, hey, development team, we'd like this third party to be removed. Now, the development team would likely somewhat laugh and say, that's great, but you're literally asking me to find a needle in a haystack. I need more context. I need to know, where are they on the web server? Where are they on the website or the app? You need to provide me all the information I need so that I can then go remove that and remediate that. So the tool also enables that feature in that it allows companies to go in and hone in on exactly where that data transfer and collection is occurring, so that in the event they decide they want to remove that party, whether it's a legitimate or illegitimate party, they can then go ahead and do so. So it really streamlines the process. And in doing so, you're really no longer required to rely on, again, vendors, partners, et cetera, to really tell you. Instead, this enables you to see it objectively with boots on the ground. So just, yeah, furthering that point, again, it really facilitates the communication between the legal and the technical teams, as well as the marketing teams, in that it allows the legal team to easily identify any of the data that raises concern, and then allows the legal team to then go in through the tool, and they're issued their own unique credentials to then explore the actual network traffic to then resolve and mitigate the vulnerability. So again, it's definitely more than just, hey, we've identified a problem and now you're on your own. We've identified a problem, and in the event you want to resolve it, or you want to enter into an agreement, or you want to remove them, you have the capability to then go ahead and do so. So one useful thing that has really come to light, as I alluded to when we first began, is Apple, right? So if we're looking on the left side of the screen, this is the tool that we developed, and it aligns well with the requirements set out by Apple. Remember, in order to have these tiles generated on an app, the developer is required to go in and answer very granular level questions. So what the tool does is it actually provides the full information that the development team will need in order to answer those questions. And the way the actual table is set up here is it actually mirrors and aligns one-to-one with the questionnaire. Now, I understand it's a little difficult to picture because the questionnaire is not in front of us. We could not access that on our own, but essentially the questions say, hey, are you collecting name? Then it says, if you're following along from left to right, it says, is name linked to the user? And remember, linked to the user is whether or not it can reasonably identify the person using the app. And it also includes personal data and or personal information as defined by applicable law. So again, real legal implications here. The next question will say, are you tracking the user? Essentially, are you using the app to collect information about the user and share it with third parties for advertising purposes? And this questionnaire, this run through from left to right, has to be completed for every single data element that is collected from the app. And in the event, again, it is wrong, or if the disclosures are not accurate, Apple has already taken the position that it's able to reject an app from the App Store, which again can have real implications. Notwithstanding the legal implications we already addressed earlier with respect to accurate disclosures. The next piece is Apple also, as we alluded to, requires that if a company is collecting personal information and then using that information to track users, it needs to obtain opt-in consent from the user. And actually, I don't know if anyone has seen this with their exploration of mobile apps on the App Store in the last couple of days. This is actually now launched this week. And when you go into an app, if it collects your unique Apple identifier, or it tracks you, then it actually, you'll see this pop-up appear saying, hey, do you give the app permission to track you and or access your unique identifier? So again, it's important that you get that right so that these disclosures and opt-in consents as required by Apple are accurately met. And the tool NT Analyzer assists with that as well and tells you definitively whether or not the app tracks the user as defined by iOS or accesses the user's IDFA, which would result in the company needing to meet these consent obligations set out by Apple.
Okay, so we know that there was a lot of nuance in what we just talked about, and a lot of it was super technical. So happy to take any questions anyone may have, if there are.
Going back to the notification requirements you're talking about earlier, and I know it varies between reasonableness and 30 days. Is that notification requirement triggered by once a company has confirmed that an employee or customers' actual data has been compromised? Because oftentimes it takes 6 weeks to even figure out what has been compromised.
Yeah, so it's a bit of a gray area, but how we typically address it is, for example, if you have a large ransomware incident and a bunch of data was exfiltrated, it's going to take you weeks to ring fence that data, unless the threat actor gives it back to you, which is the best case scenario. And yes, then going through that data, the e-discovery process takes time. You have to ingest the data. You have to have technical and manual review of that data. So technically, we would say the trigger starts once we know personal data was within that data set. I would say you can't say, well, today I learned a California resident's information was impacted, so California law. It's more of a comprehensive, we found personal data, triggers have started.
Okay. We have one from online, and I'm going to try to paraphrase this. After an inadvertent disclosure of PII, what state could be concerned about if it is low-level risk of data and a low-level number of individuals who've been affected?
Yeah, sure. So it really depends on what the data elements are. So what is a low level of risk? If the data elements trigger data breach notification laws, then you need to do an analysis on a state-by-state basis. You can't just focus on certain states, but it's kind of a comprehensive analysis. Unfortunately, US laws, they're not triggered on the number of individuals impacted. You can have the inadvertent disclosure of someone's name and SSN and decide, in Texas, for example, there is no risk of harm. Obviously, companies can make their own risk-based decisions, but in Texas, there's technically not a risk of harm. And so if you accidentally mail someone's name and social security number, although I guess, I don't know if paper records apply in Texas, but if you mail someone's social security number, or you accidentally email someone's social security number to another employee, they won't respond to you, they won't tell you they've deleted it. Technically, the law has been triggered because the unauthorized acquisition of a single individual's name and social security number. So it's really has to be a comprehensive analysis of each state law and the data elements at issue.
Thank you for the very nice presentation today, both of you. Question regarding the NT analyzer. If you're able to answer this, I'm wondering if it's strictly speaking an in-house tool owned and operated by the law firm, or whether maybe the law firm farms it out to a separate entity, which the law firm may very well control. But if it's really under the roof of the law firm, technically speaking.
I'll kick that to Dan.
Yeah, so it's a great question. So technically speaking, it is in-house and developed by the law firm. We do work with a third-party vendor that we've brought on from actually Texas, from Austin, Texas, who helps us conduct the testing. But in the event, of course, you have further questions on that, I'm happy to discuss that a little bit further online or offline on an email or over the phone. If helpful.
And I guess one point that I just wanted to make that I realized that we didn't make during the presentation is that, we use the NT analyzer to do this, but regulators are also developing their own tools to go out and collect network traffic, and they're doing this analysis on their own. So we have had, and I think the EU just released a tool that its regulators are using to go look into companies to see if companies are missing this type of data. So it's not just us doing it. And I think that that's another reason that it's just super important to understand, because regulators are now proactively going and looking for that data leakage.
Yeah, that's a very good point, Tristan. And I would also add, well, two things. One, at least from the US side of the shop, we do take the position that any of the legal findings are protected by privilege in the event that a company were to engage for the use of NT Analyzer. So that's something that's important with respect to that. The next piece, I noticed that there was a question posed in the chat about how the tool actually maps to the legal requirements. And it's a great question. And the way we're really able to do it is, as we said, we developed the tool in-house through our own technical lawyers, including myself, as well as a partner in New York named Steve Rosa, who is actually an engineer as well. And the way the tool really works is we've developed a back end that is able to parse all of the data and then through the network traffic, and then the report that's generated actually defines and organizes the data elements that are collected through the definitions and categories defined by the law. So for example, if in the network traffic we find that first and last name is being sent from a mobile app to a third party inadvertently, it will say first and last name detected, and then it will also in a table then tell you which third party is receiving it. And it will say, hey, third party X is receiving it, and then it will define or categorize that third party through the category as defined by the CCPA. So it will say, third party, or it will say first party, or it will say service provider. And we've actually done that for many other laws outside of the CCPA as well as iOS. So it really allows you to map out those requirements through the lens of the law that you're most concerned with.
Okay, I have another question. So we've got CCPA, we've got CPRA out of California. Virginia has CDPA. Who's next?
Yeah, so as of even a few weeks ago or last week, over 25 states have introduced their own privacy laws right now. It's a matter of time until more and more laws come on the book. I think with this administration, again, completely speculating, but I think the likelihood of having a federal law is not completely unlikely. Again, but with respect to the state laws, it's just they're constantly being introduced. And I know for particular Florida, New York, Washington State, and others have all gone ahead and introduced laws.
And just a point on that is California was the first state to introduce a data breach notification law back around 2010, 2011, and now all 50 states, DC, and all territories in the United States have data breach notification laws. So that's where we're going.
All right, one more. Has the technology ever been used in a criminal case to secure a conviction?
That's a good, no, not to my knowledge at this time. I will say though that the early stages of the technology has been used and was used in plaintiff's class action cases, particularly with respect to health data. And actually a point worth review or emphasizing here that Tristan alluded to a short while ago, I know we're at time, but I'll just quickly just say it, in that there has been instances where plaintiff's class action attorneys, as well as regulators, have actually used their own network traffic, taken a screenshot of it, and provided it in the tool during an actual regulatory investigation and or a trial. So it is definitely something that companies need to be aware of. If we can see it, then so can others. It's not like we're the tool's finding a needle in a haystack and saying, it's a gotcha moment. Right, this is a public-facing app and or website, so it's by definition available to the public. So the regulators and plaintiffs' class actions are able to run their own analysis with respect to network traffic. Of course, it doesn't parse it through the lens of the law, but they are able to at least provide a technical piece of that.
All right, the questions keep coming. How does the tool map the legal requirements? Where does it obtain the legal requirements?
Yeah, so I think I briefly hit on that. We're able to go in and implement as lawyers the technical, the legal requirements that then the tool is able to technically follow and categorize the findings in the report through the lens of that law. But again, I understand that's a technical and nuanced description, so happy to discuss it with anyone at any time. If they have any questions, just feel free to drop me a note. And Tristan as well, of course.
Excellent. Well, I think we've run our time today, and I'd like to give a big thanks to Tristan and Daniel. And if anyone has any further questions, they can contact them directly.
Yeah, and sorry, we didn't print the PowerPoint, so if anyone wants one, just let us know. We'll get you a copy.
Let's give them a hand. Thank you.
Thanks, everyone.